Okay, testing again. Is it better? Is it better? I think I clicked a wrong button just now. I tried to upload this into the cloud. That's why it's caused a bit of internet problems. Now it's better, right? Okay, very good. Then we proceed with the first question. Just remember, do not study that much of subject materials for TP. Do more question. Once you get familiarized with the past year question, automatically you can answer this paper. Professional paper, I'm going to teach with way of practicing past year question. Okay, master your strategies well. Huh? Okay, so question number one, Poon, an advocate and solicitor, and a member of Malaysian Bar, we have newcomers, okay, did not apply for a practicing certificate and professional indemnity insurance for year 2021. In fact, he left Malaysia in October 2020 for a solo expedition of the Silk Route on his bicycle. He informed his secretary to attend the needful regarding all his brief and stated that if luck is on his side, he will be back in mid-2021 and resume his practice. Poon has not informed the Bar Council that he ceased practice as is required. Just try to understand this paragraph first. Subsequently, what happened? A complaint was lodged with disciplinary board against Poon by the president of Malaysian Bar for breach of Section 29 and Section 31 Sub-Rule 2 and Section 36 Sub-Rule 1 of LPA, which may constitute a misconduct under Section 94 Sub-Rule 3 Sub-Rule K of LPA. And Poon was subsequently asked to appear before the disciplinary board to make his representation, but he did not do so. Okay, as he received no notice that effect since he was still on the road trip because he went to the bicycle route, silk route trip, isn't so? So the notice was, however, sent to his office and was received by his secretary. And what happened next? DB imposed a penalty open Poon with a fine of 1,000 ringgit payable to disciplinary fund. And Poon learned the order of DB when he entered his office in November 2021. So Poon, of course, he feel that his position is jeopardized because he was not around, and then he only came back to office by November 2021. So he filed an appeal to High Court against DB's decision, citing the chairman of the DB as first respondent and president of the Malaysian Bar as second respondent. So first and foremost, identify the questioner always if there is these sort of words, sensitive words, you are going to advise Poon on the following. So your question should be tuned to advise Poon. Okay, we'll look at question A. What is seizure annual and why it is necessary and important in his application for practicing certificate? Your answer should relate to decided cases. Okay, so you are going to advise Poon, you are going to define what is seizure annual and why it is necessary and important for his application for practicing certificate. Okay, so this is our question number A. Right, I'm going to put forward to you my suggested answer. Okay, first of all, you go with the chronology event or the structure of the question itself. You must let the examiner know what does it mean by seizure annual. Okay, if you look at your section 2 of this LPA 1976, it clearly defines what does it mean by seizure annual. Okay, if you are free or you have the statute with you now. You can have a look. Otherwise, you can look at my answer provided. It means any certificate, right, issued by the council under Section 32 LPA 1976. Okay, so this is what it meant by seizure annual. You have to further elaborate on this interpretation because it simply says that you have to cross-refer to Section 32 to get further information about this seizure annual. Hence, your Section 32 only tells you about the issuance of seizure annual. You all can follow me. You have to read how to read statute, please. Okay, I hope you can follow me so far, right? So, in further elaboration, it means seizure annual is actually an annual certificate that every advocate and solicitor in Malaysia must apply in order to practice law for the upcoming year. That means to say, if I'm to practice in 2025, this is 2014, isn't it? By end of the year, usually June lah, the bar council will issue out the application is open. You have to apply. Okay, this is like our annual license, renewable every year for us to practice. Okay, so a lawyer who is and has been in active practice must remember the word active practice under the meaning of Section 13, Sub Rule 1 of your LPA must have a seizure annual plus practicing certificate. Okay. That means to say, if I'm to represent to you that I am an advocate and solicitor in Malaysia, I must have two things. One, seizure annual issued by Bar Council, and second thing, practicing certificate issued by the registrar of court. Okay, I'll show you the sample later. Okay, so this is decided in your KPM Hikmat Sendirian Berhad against Tay Kim Sui case. This case is very important also for your documentary hearsay evidence. It is a landmark case. So for your further information, usually you will not require to cite a lot of decided case, but it is extremely important for you to cite the statute. I think for those who had attended my class before, you must have known what does it mean by section. Okay, cite the statute that passed by Malaysia government, then only you fall back to the application in reliance with decided case. This is how we play. All right. Okay. So this is my personal what we call seizure annual for your understanding. So this is seizure annual. Okay. Seizure annual. Seizure, okay. You can see that this is pursuant to Section 32, or we rather put it as Part 3 of LPA 1976. So it's stipulated what is the requirement. Hello? I think internet got problem. Can you all still hear me? I was being pushed out just now. Hello?
Yes, Doctor.
Can okay, sorry. I think my internet today is some problems. Never happened before. Let me just check. Okay, can still follow me, All right, good. Okay, fine. So where were we? Okay, In order for you to get this seizure annual, okay, you have to comply with the proviso of section 32 sub rule 1. Okay, and I'm the person who is under application of the section 32 sub rule 1 sub rule A. Okay, you get me? Okay, any person that is not coming after the requirement of section 32 sub rule 1 cannot apply unless it is determined by section 33. Okay, there is a certain requirement that enable bar council whether this person is fit or not to be issued with seizure annual. Okay, and one more thing very important is that if you are maintaining the firm's account, you have to give accountant's report according to section 79 of the act. Okay, and you cannot owe any compensation fund or the state bar subscription, okay, under the act. You must pay yearly, and you intend to practice under the approved name lah. That means to say which law firm. Okay, so this is what it meant by seizure annual. Okay, at the same time, okay, during the application, when you are clear already by bar council will submit your name to the court. After that, usually on the same day lah, the court will issue with a practicing certificate. This is your PC, practicing certificate. So under this certificate, I am an advocate and solicitor of High Court of Malaya. Malaya, that means I can practice in Mahkamah Tinggi, Session, Magistrate, Rayuan, Persekutuan in Peninsula of Malaysia only. So this is practicing certificate. Don't confuse yourself. Okay, one is seizure annual here, and you have your practicing certificate issued by the Mahkamah. So seizure annual, I repeat, is issued by the Bar Council. Without one of these, usually you have both lah. I do not recall I'm reading any case law that you only have seizure annual without practicing certificate because everything is online system now. Okay, so you must have both in order to practice. Only the party that issue the seizure annual and practicing certificate is different, but the application is now combined in one. Okay. And why do you need seizure annual is because, as you can see, seizure annual is issued by Bar Council or Malaysian Bar to its member, subject to important provisos inside this LPA. This come back to our question. All right, our questions where Poon had gone somewhere to ride his bicycle and then he neglect to renew his SAPC. Okay, so you must do annual declaration to the Malaysian bar as well as to the court so that the say annual declaration would include you want to practice as an advocate and solicitor, and you are not being engaged as an in-house counsel or being employed elsewhere. If you are like me, you have companies, for example, running a companies, you must declare your interest. For example, I'm shareholder and non-executive director of certain companies. You must put it inside a statutory declaration. So this is under your section 29. And section 32 cited the requirement of Bar Council to issue the applicant, which for, I told you, just now you have seen my seizure annual, I'm the applicant under section 32, sub rule 1 and sub rule A. Okay, very specific one, because we play by the rules and statute. as well as Section 33. Section 33 required the seizure annual to be issued by Bar Council for certain group of people. For example, those who had been discharged from bankruptcy. Take for example, if I got bankruptcy order from the court, bankruptcy order from the court tomorrow, I owe people 200,000 ringgit. Then automatically I cannot apply for seizure annual because under the Professional Acts, anyone that is deemed bankrupt, you cannot be a professional. All right. I hope you understand. So Section 33 provides special group of applicants. After you have been discharged by DGI, Director General of Insolvency, from bankruptcy, then you can apply. So you fall under Section 33. As well as if you have previously been struck off from the role, you committed some sort of grave misconduct, and then you got struck off from the role of advocate and solicitor, but subsequently you apply to reinstate or restore to the role that had been granted by the court, then you fall under Section 33. Okay, etc. Okay, and some more, you must look at Section 78 because the facts provide you that Kun did not apply for professional indemnity insurance. It's just compulsory for an advocate and solicitor before the renewal of his or her seizure annual to apply for professional indemnity insurance. Okay, very important. Okay, we'll discuss in our next question. Okay, this is clearly provided under your section 78. And as you have seen, I have shown to you if the said applicant, let's say my partner, Miss Christie, she maintained the office and client account. She will bear the responsibility to submit an accountant report, all right, to the Bar Council prior to the application of her seizure annual. So long she is the one that in charge in the maintenance of the firm's account, regardless if it's client account or the firm's account. Okay, so unless it is exempted lah under section 79. All right, so this is provided under the case of Yip So Shan here. Okay. Okay. Why we need to impose such a strict requirement, okay, for those applicants? I said to you before that if you do not have a seizure annual, automatically you do not have a practicing certificate, then you cannot call yourself as an advocate and solicitor because you do not have practicing certificate. You cannot appear in front of the court. You cannot represent your client in any matters in regards to do with lawyering and solicitor things. Okay. And this proviso actually ensure continuous professional compliance. That means we have to comply with all the Bar Council ruling, LPPER, okay, publicity rules, solicitor accounts rule, and so many others. In compliance towards the rules, or you have any misconduct, the Bar Council has reserved their right to issue seizure annual to you. Okay, very important. So seizure annual actually serve as a good evidence that a lawyer had met all the requirements set out by Bar Council to practice law for that year. Okay. And these requirements include payment of annual fees and also adherence to rules and regulations set up by Bar Council. Very important. So in other words, it could be inferred that Bar Council trying to uphold the legal standard and professionalism by holding the power to issue seizure annual to the practitioner. If you do not obey the rules, I'm sorry, you are not longer fit to play your role as a as an advocate and solicitor in Malaysia. This is how it goes. And of course, it will protect public from unqualified and disreputable practitioners. Okay. And it is very important under section 36 of LPA for you to practice or for you to be called an authorized person. Okay, authorized person, that means advocate and solicitor lah, that can have a legal standing in a court. There are two requirements. Number one is the name must be on the roll of advocate and solicitor. Once you are being called to the bar, automatically there will be an instrument issued to you. Your name will be registered as inside the roll. It's actually is roll means something to do with our England, history. It's inside the register actually. Okay, and the said advocate and solicitor must possess a valid practicing certificate. Okay, so this is under your section 36 LPA. The famous and landmark case that you must take into your mind will be Diljit Kaur against Majlis Peguam Malaysia. Okay, if you do not have these two, what is going to happen? It will be an offense, a criminal offense punishable under section 37 of LPA's 1976. That means to say, if you are authorized, if you're not authorized, one thing is your name, although your name is on the roll, but you do not have this practicing certificate issued by the court. As I have shown to you earlier, you are not authorized, That means to say you can't even go to court in that legal standing. Okay, and you will get punishment. So what is the punishment here? If you can see your section 37 sub rule 1, if you are found guilty for this offense and been convicted, then you are subjected to a fine not exceeding 2,500 ringgit or imprisonment for not more than 6 months or both. So this is under your section 37 LPA. So remember, 36, 37, very important. Okay. So this is why. So come back to the question, you still need to advise Kun. Okay, so what happens on the fact? You do not need to rewrite the facts again. Clearly, on the facts, Kun did not renew his seizure annual or practicing certificate for year 2021 because he's on the road trip, but left his law firms to continue to be run by layperson. Summarize it. And indeed, he had breached section 29, 31, sub-rule 2, and 36, which amount to a misconduct under your section 94, sub-rule 3, sub-rule K of LPA. So therefore, what you are going to do with his advice, you must say that he has a weak case against Malaysian bar because he's appealing against the decision of disciplinary board, correct? You must tell him, oh, since you did not renew your seizure annual practicing certificate, so you breached the rule already. You have a weak case or your merit of the case is very poor, okay, against the punishment imposed to him. So this is your final conclusion. All right. So you answer a complete, I mean, you give a more comprehensive answer to this question. Okay. So I hope we can clear with number 1A and B. Discuss the issuance of professional indemnity insurance and its importance to Poon in his legal practice. Okay. So what is the suggested answer? I have said to you, this PII thing, professional indemnity insurance, if you look at your section 78 or 8A, okay, power to make rules on professional indemnity. So in the year 1992, under this section 78 of 8A of LPA, Bar Council or Malaysian Bar had make it compulsory and mandatory for an advocate and solicitor to subscribe to professional indemnity insurance before he or she could be issued with seizure annual and practicing certificate. So under section 78A LPA, Bar Council did in fact use his power to make such rules. Okay, listen carefully. And the case law you can use is Tetuan Bakar and Partners against Malaysian National Insurance Berhad. Okay, so this is already compulsory, whereby Malaysian Bar or Bar Council had designed a master's insurance scheme, which is applicable universally across Malaysia. That means to say, for those advocate and solicitor, the terms and the conditions are same. Okay, and now our PII insurer is Marsh Insurance for your information. Okay, so this is the master policy given by the Bar Council, whereby all its member, okay, must subscribe to this plan. Unless you want to top up, that is different issue. So this is the minimum coverage is one lawyer is 250,000. Okay, and we fall back again, we must discuss the question asked, okay, because the question asked to discuss the issuance of professional indemnity insurance. So how is the process? Number one, usually a lawyer or law firm need to assess the level of its practice risk. Usually, conveyancing lawyer will subscribe to a higher indemnity policy because nowadays the property value is very high and the negligence case among the conveyancing lawyers is quite high. Usually they will go for 5 million, 10 million. Whereby litigation lawyer probably the negligence rate is lower. We subscribe maybe to 1 million, 500,000, something like that. First, you assess the coverage need, and then subsequently you apply the insurance. So you need to supply Marsh Insurance, that is the insurers, in regards to the details of our this. Okay, very important. They'll ask from you also. They'll ask you where you are practicing and what is the services. Okay, and more importantly, do you have any pending claims or disciplinary action? Because if you have this sort of problem, for example, you have disciplinary action or any previous claims, your base assess, we call assess, assess will be higher. That means to say you will be required to pay a higher insurance premium for that year. Okay. Subsequently, if you are clear this, and they will provide you with the calculation how much will you need to be paid. And then, of course, there is policy and terms and condition will be attached to you. And you will be required to compliance with the whatever policy wording that insurance. Okay, very practical question. And I think it will not fall in the textbook also for this issuance of insurance. And why this professional indemnity insurance is important to Poon's practice. So you relate back to your question asked. Number one is, of course, risk management. Because as an advocate and solicitor, you are personally liable in terms of contract or tort of negligence against any errors, omission, or breaches that you have committed throughout the process of engagement or retainer. All right. So this insurance scheme serve like a protection, It's like a cushion, like a safety net to protect lawyers against any claims or damages or whatever settlement dispute that could have coming from the complaints of the client. All right, get me, eh? Okay, so this is for the risk management on part of lawyers and law firm. And second thing is about client protection. Okay, if let's say, for example, a client had engaged a lawyer to do a property transaction. Subsequently, the amount of 5 million ringgit was actually deposited to the lawyer's bank account, and suddenly the lawyer swindled the money and ran to other country, escape lah, elope with the money. Okay, so what happened? The client will suffer loss. So this professional indemnity insurance actually protect the clients to claim back the money they lost due to any professional negligence. So in the other word, it is very important for the client or the society at large to trust us as an advocate and solicitor so that the integrity of the legal fraternity could be maintained. All right. And lastly, it's very important because this is part of your regulatory requirement. You like it or not, you have to subscribe to professional indemnity insurance before you can practice for that particular year. So this is why it is important. All right. And C, whether Poon has named the correct parties to the appeal. Okay. We do not need to argue whatever that is not asked in the question. Okay, you have a look here. Last paragraph. Dissatisfied, Poon on his own file an appeal to High Court. This is of course pursuant to your section 103E of LPA. Okay, citing the chairman of disciplinary board as first respondent and president of Malaysian Bar as second respondent. Okay, so whether it is correct or not. Okay, so my suggested answer is okay, correct parties in appeal. You want to make your answer look sweet and nice because examiners would have read so many answers. Sometimes their eyes are a bit tired. So put headings, put headings. It will help you a lot to discuss about what is coming next from your mind. Okay. So you put an introductory statement first. What you're going to say here, the appeal for the decision made by ASDB. So advocate and solicitor disciplinary board. The decision for disciplinary action actually does not come from Bar Council. It comes from an independent body we call advocate and solicitor disciplinary board. It has got a separate website. You just Google ASDB, you'll see it. Okay. So this is independent from any interference of Bar Council or Malaysian Bar. It works on its own. But of course, the members, the council member, the disciplinary board members are among the senior most member of the bar and also retired judge. All right. So this is provided under your section 103E of LPA and LP, a legal profession, disciplinary proceedings in the bracket, appeal rules 1994. So you summarize it as rules 1994. Okay. And you have to get the parties right? Because this question. So rule 3, sub rule 1A of rules 1994, I refer to legal profession, disciplinary proceedings and appeals rules 1994. The party who appeals is known as appellant, and the party against whom the appeal is known as respondent. So get the definition. What does it mean for parties in the appeal first? All right. And you further refer to your section 103E of and subsection 1 and A. Okay. So Poon obviously is the aggrieved party who is affected by the decision of DB under this misconduct. That's why Poon could be cited as appellant. So this is part one of your answer. All right. Don't straight away go to the respondent because 6 marks, 6 marks. So you must know what you are talking about. All right. So first part, I think is correct. Appellant because Poon had appeal on his own, isn't it? So that means to say appellant part, we have no issue. So we clear this stage. Secondly, we look at the respondent part. Is it correct or not? So this is the main discussion here. All right. So you make reference to your section 103E subrule 7. You said that disciplinary board shall not be cited as party in any appeal under this section. So in broader sense, if you stretch the section a little bit more, DB cannot be cited. So chairman of DB naturally could not be cited as first respondent. So this is your first comment. So secondly, the president of Malaysian Bar has anything to do or not? It has nothing to do. Okay, I will submit that he's just the office bearer of Malaysian Bar. Okay, if you want to put, you can further submit that Malaysian Bar and Advocate and Solicitor Disciplinary Board, ASDB, MPM, Majlis Peguam Malaysia, totally two different things. Therefore, she should not be cited as in her own personal capacity when performing her duty. Okay, so this is your second submission. So, but you still have to advise Poon to do the right thing, right? Okay, so usually how we cite, we have to cite the right respondent to be Malaysian Bar or Majlis Peguam Malaysia. Okay, this one, unfortunately, I could not find in any case law. So I would say this is just a guidelines based on case law. If you want to cite, you cite against those case like diligent call, you recycle against Majlis Peguam Malaysia. So you submit that the right respondent should be Majlis Peguam Malaysia. Okay, so this is your complete answer to Vice Put. Okay, so far so good. So far so good, huh? Bar council is Malaysian bar. I think it's interchangeably used, but in a broader sense, we call Malaysian bar. Okay, bar council is just referring to the executive committee. Okay, so next question, Gun, an advocate and solicitor acting for defendant Dr. Ho. This one you have to read the question carefully. Okay, so Gun acting for Dr. Ho, an orthopedic surgeon in medical negligence claim, intends to apply a discovery of documents against plaintiff solicitor Rajan, primarily seeking all the medical reports pertaining to the plaintiff's treatment at other hospital. So Gan's intention, the lawyer's intention, is to ensure that all medical reports will be disclosed for the trial before the hearing date. Gan is unsure whether the medical reports will be protected by privilege. So advise Gan. So please read your question again and over and over again until you understood what it asks before you jump simply into answer. Because the examiners, based on my personal experience, it is very strict. Okay. So my suggested answer would be, okay, it is surmised that, okay, Gan, what is his role here? He's the defendant lawyer. He's acting for Dr. Ko in negligence claim, right? He wished to make a discovery application under Order 24, Rule 1, Sub Rule 1 of Rules of Court 2012 against Rajan, plaintiff lawyer, save to Order 34, Rule 4, Sub Rule 2 of your Rule of Court. Okay, this Order 34 rules of court actually refer to your pre-trial case management proviso. Okay? And your subsection F provided that order either party to the action must furnish the report of an expert and fix the time for the delivery of such report. But subsequently, there's a proviso J, subject to all just exception as to privilege, direct the parties to make any disclosure or provide any information the judge considers relevant to the issues in action. Okay, so you have to read the law in details. It is not just about LPA anymore. It comes to the role of your rules of court as well as your evidence act here pertaining to the privilege status of a certain document. So that's why PP is very difficult. All right. No doubt, you submit further. No doubt, in civil proceeding, it is tried law that there should not be any surprise attack. This is true. Okay, so this is the principle that Gunn is relying on when he's making discovery application because he wants all the documents to be screened through before the trial, before the hearing date. Okay, subsequently, you say that scrutinizing on the facts, Gunn is most likely because he's in a position to to defend Dr. Cole, an orthopedic surgeon, right? He's most likely seeking to discover the expert medical reports of the plaintiff's side. Okay, you give reasoning why. Gunn, who is acting for Dr. Cole, will have gained access towards all the medical notes because the negligence will have indeed happens in Dr. Cole's medical facilities, right? So he will have all the notes because he's representing the defendant, right? Okay. So according to case of Sapuran Court against B.A. Rouse, the medical notes for the insight that is available in the hospital or the clinic or medical facilities are not privileged. Okay. Why is that so? Because they are the factual evidence. Okay. That means to say they are reflecting to the facts, fakta case. Anything regards to fakta case usually apa nama are not privileged. Okay. Get the difference, okay? So this is factual evidence. Nevertheless, the landmark case here is actually Dr. Pritam Singh against Yap Hong Chun, whereby the late judge Gopal Sri Ram said that the opinion, sorry, I missed out a O here because everything is just freshly done by me, obtained by the plaintiff are subject to legal professional privilege. That means to say now you have plaintiff against Dr. Ko. Correct? Are you all with me? Can you hear me? I think the line is breaking again. Sorry, sorry. Okay. Okay, good, good, good. So sorry. Okay, where were we? Dr. Pritam Singh. So I repeat the point. If it is DHT folders medical notes inside the hospital, that is amounts to factual evidence. Kenyataan bukti fakta. So it is not privileged. Whereby if it is under expert opinion, for the case of Dr. Pritam Singh against Yap Hong Chu, it is privileged. Okay? So what proviso in the law said it is privilege? This is under your section 126. sub rule 1 of your Evidence Act plus Order 34, Rule 4, Sub Rule 2J, which I had shown you earlier. All right. So two provisos said that if it is expert opinion, for example, the defendant look for a third party, a second opinion, in order to help the doctor to be negligent, you need to have Bolam test. You need to compare the standard of care of Dr. Call with another similar orthopedic surgeon. So this is called Bolam test. So the opinion of this third party doctor that will probably in his report say that, oh, Dr. Paul had fall below the standard of care because he did not monitor the patients, he started the wrong medication, he's not following clinical practice guideline, for example. So this report itself is privileged under section 126 sub rule 1 Evidence Act and Order 34, Rule 4, Sub Rule 2, Sub Rule J of your rules of court. I hope you are clear with me. Okay. In conclusion, Gan is advised that his discovery application will fail. You must be firm, you cannot in between. Yes, only yes or no. Your application will be allowed by the court or dismissed by the court. That's all the complication. So you stood firm with your knowledge to say that application, the discovery application under Order 24 Rules of Court will fail under the ground of legal profession privilege. All right. Okay. So second question. All right. Johan was admitted to the degree of the Uther Bar from the Honorable Society of Inner Temple in 2021, and open completion of his privilege was called and admitted as an advocate and solicitor of the High Court in Malaya in February 2022. Soon after, Johan was engaged by his friend Azmi, who practiced as a solicitor to act as a counsel in a civil claim by Azmi corporate client, Gadong Berhad. So what happened next? Johan was ill prepared for the trial and had overruled Azmi on the production of material documents and witness to be called. Johan had also decided not to cross. Hello? Can you hear me? So sorry, I don't know why the line is so breaking. Let me just give you a minute and reconnect back. Are we back online?
Yes,
Hello?
sir.
Sorry.
Yes,
I'm
yes,
so
we can hear
sorry
you.
for the technical complications caused tonight. Today the network is not with us today, right? But never mind. So what happened next? So Johan performed badly in the court, and Gardong's claim was actually dismissed. And in the main, the learned judge remarked that the plaintiff's case was undone by his own counsel's arrogance and bargaining. This is a very bad remark. That means to say the plaintiff case was actually dismissed not due to merit, but underperformance of his own counsels. So Gardong's new solicitor, Solomon, had raised with Azmi and Johan that both of them had been negligent in the conduct of the case. Johan claimed that in hindsight, he could have better prepared and tender all relevant evidence. But as a counsel, he is protected to be sued because for the issue of immunity. So we are in the position to advise who? To advise Azmi. Okay, very important, right? Where's my pen? My pen also go missing. Can you all see my slides actually?
No,
Huh?
can't see.
Can't see
No,
your
there is no
slide.
slide. No slide.
My God. Oh dear, wait. Is there any slide now?
Yes,
Is there
sir.
slide? Okay, thank God. All right, so we are in a position, there are two defendants now. Gadong against number one, Azvi. Number two, Johan. Okay, so make a bit of notes here like that. So this is the case here. Okay, we are in the position to defend Azvi. So make sure that you know your roles in your examination. Very important. So you have to advise Azvi accordingly. Again, I will divide my answer into heading. Number one is the issues of negligence. Okay, naturally, because you are talking about negligence, I will not spend a single time to elaborate on contractual obligation. I will not even talk about the breach because PP paper is not about to complete a perfect answer. It's to submit whatever that is the point that is makes sense and reasonable. All right, remember that. Don't spend a long time discussing about the law. You will lose out for the other question because you need to answer 5 questions. Oh, okay. So ask me, oh, a duty of care. I will straight away submit. This is the first element of negligence towards his client, Gadong Berhad. So despite the fact that Azmi had engaged and underperformed counsel Johan, Azmi could not escape his liability of negligence. So, reason? Because Gadon Berhad had entrusted the case to Azmi, isn't it? Azmi is the one that called Johan without actually knowing that Johan is poorly performed. Lah. So, you must say the client and solicitor relationship in the bracket, duty of care was founded lah, or form. Okay, simple. Okay, so this is on the issue of negligence. And due to the poorly managed case, so you discuss second element. First, duty of care. Second, breach of duty of care. Then what you need to submit. Okay, so you said that Gardon lost the case in the court of first instance. There was a clear breach of duty of care where Johan and Azmi performed below the standard of care as required. Okay, according to the standard of right thinking members of the bar. Any professional negligence, you cannot use reasonable man test. You have to go back to Bolam test. Okay, Bolam test. Medical negligence, because I'm quite this one, I'm previously a doctor, isn't it? The correct test now, Bolam plus Fulfiona. Okay, remember that. Later on we discuss lah when we have a opportunity for general paper. But for the sake breach of duty of care, okay, Gardong actually lost the case. So what I'm trying to say here is causation. You remember your 4 element of negligence. Okay, so this is the expectation. You need to know substantive law in order to answer, to give a beautiful answer. Okay, so as a result of the losing case, the client Gadong Berhad suffer loss and damages. So 4 elements of negligence, okay, fulfilled. Subsequently, you said that Azmi shall be jointly liable to the negligence suit. Okay, so this is your conclusion. And you can cite this case, Syarikat Xiao Tekwa Realty against Malek and Joseph Au. Okay, very simple. Okay. So you are to discuss because Johan contended that he's protected. I'm not the one that manage the brief. I'm just acting as a counsel during the trial process. Okay, so you have to advise on the issue of counsel's immunity. So Azmi is advised that Johan cannot claim immunity from being sued for negligence. The immunity enjoyed by the counsel was actually a long lost matter, according to the case of Ronda against Worsley, due to public policy reasons. In fact, Malaysia has never ever had this thing called counsel's immunity. So the client can sue their legal counsel for negligence, and the counsel has also contractual duty to use reasonable care and skill to represent their clients. So therefore, Johan will be liable for negligence caused by his arrogant act. Why I said so? Because the learned judge had commented, okay, the commented. So you use back the fact to show that you actually read the question. So counsel immunity is not what we call enjoined by Johan. So this is your second part of your answer. So what about the third part? The third part, further, you need to advise how much I need to pay as a comprehensive advice. Definitely, Azmi will be named as a party and Johan will be named as a party. Okay, so I will submit that since Azmi and Johan are jointly and severally liable for the negligence suit, the apportionment of quantum of liability shall be determined on the surface of evidence. Okay, the court shall scrutinize who is liable, who shall pay more to Gadong, which suffer loss. So this is how you advise the client. You cannot say Johan made a clear mistake whereby Azmi did not do anything. Cannot. It still fall back on the evidence. And the evidence in this question are not so clear. Who should be liable more? All right. So this is how you submit. And this is probably uh, the answer for it. And what is the next step? Hmm. In view of the possible negligence step, ASME shall be required to notify the professional indemnity insurance in due course. Okay. Apart from that, because negligence happened already. So what is possible outcome to ASME? Advise thoroughly. First, you are going to receive a summon, probably from that fellow, Solomon, isn't it? Second thing, the worst part, you might get a letter from SDB. You don't want that. So in your advice, you will say that Azmi is always also advised to reach a settlement with his client Gado to minimize further damage to his career, as negligence could be caught as a misconduct under section 94 subrule 3 subrule N of LPA. Okay, then further advice, should Azmi be open, transparent, and admit his liability, the client may choose not to complain against him. Okay, very, very important. So this is reflecting that you are knowing this is what happens now in reality. All right, this is what happened, and this is probably what we are advised to do. Okay. And question three, when I look at question three, I have a feeling that you should not answer this question because it is entirely on the understanding of this case law course called this Wolf and others against HB, Clifford and Sons. To be very honest to you, before I read this question, I don't even know the case exists. All right. Mavinder asked, Azmi is both contractually and negligent. Yes, correct. Correct. No, no, no. Both of them are actually contractually liable and tortiously liable. You cannot say that there's no written contract. There's always an implied term, implied contract, implied retainer. Since you decided to be a counsel for a case, even though you do not sign any agreement with the client, there is an implied term inside the agreement. Okay, oral agreement is recognized in Malaysia. So very difficult to run away from that contractual duty. All right. So we move on to question three. The law thus become well established that the solicitor or counsel retained in an action has an implied authority as between himself and his client to compromise the suit without reference to the client, provided that the compromise does not involve a matter collateral to the action and ostensible authority. as between himself and the opposing litigant to compromise the suit without actual proof of authority, subject to the same limitation, and a compromise does not involve collateral matter merely because it contains terms which the court could not have ordered by way of judgment in the action. For example, the return of the piano in Prestwich case, the withdrawal of imputations in Matthew case, and the highly complicated terms of compromise in Little against Bradbury per Brightman, LJ, in Wolf and others against HB Clifford and Sons. If you read this and you do not understand, as I did my first reading, do not do this question. Okay, I repeat, if you do not understand what is it about, do not try your luck. It's not like that. Okay, it doesn't work and it will not work most of the time. Okay, so we are asked to, based on the above statement, discuss the following. You see or not? Based on the above statement, So it's not based on your general understanding about how client solicitor relationship arise, what is retainer. No, you have to relate back to these statement, which I myself have not heard lah till today. I mean, until yesterday lah, where I complete this question. All right. So question 3A. The solicitor and client relation in the context of this case mentioned, because you have to base on this statement in answering the question. Prestwich, Matthews, and Little against Spreadbury, as referred by Lord Justice Brightman here in Wolf and others against HB Clifford, can arise in the usual manner with any legal representation. I complete this after I do reading about this case. So during examination time, if you're not familiarized with what this statement coming from, no, it's a strict no. Okay. So the solicitor relationship could arise from engagement for legal representation. Okay, that is the first situation. Okay, and it could also be implied and also ostensible authority. Okay, that means to say the solicitor, once you call me to help you with the case, I straight away can be your alter ego, sort of like agency principle. I act for you to appear in the court. Sometimes you do not need to come to the court, correct? And some of the case, so long it does not jeopardize your interest. If I'm acting out of your good faith, I'm acting for your best interest, I'm not liable. I'm still within the scope. Can understand? So I have total authority to make what do I think that is appropriate for you. For example, I made this notice of application for discovery against the party. You cannot say I do not have authority to make open your behalf. So this is what it meant by authority. It could be ostensible, that means apparent one, very obvious authority you sure have. And it could be implied. Implies means to make things, I mean, still fall back to our contract law. If you still remember, um, absurdity rules. If let's say, for example, if the terms are not implied, it will be absurd, or it could not affect the business efficacy test, the Moorcock principle, etc. Okay, so this is how it is being done. Okay, if you do not have full understanding, this case better skip lah. No need to read also. Okay. So in Matthew case, the solicitor could have arranged for the withdrawal of certain imputation, which likely involves strategic, legal, and negotiation skill. Okay. And in Little against Bradbury, the solicitor dealt with when the thing is too complex. Okay. And demonstrating, yeah, you need legal advice. You need some sort of legal opinions. The client would not know. So that means actually you have such authority. Okay, understand? And the third one is trust and reliance. Of course, this is self-explanatory because the client will rely on you because they have trust in your capacity as a legal professional. Okay, and apart from that, We are also subject to ethical and professional obligations. So these are how solicitor and client relationship could be arise according to Wolf and others against HB Clifford and Son. Can get me, Okay. So B, what is retainer and in what form or forms this retainer may take? Okay. So retainer fee is basically an front payment. We lawyer is not selling things. We are not selling watch whereby you can feel it, you can touch it, and you can bring it home. We're selling our professional advice and also professional service. Sometimes it's just out of the air. When you are becoming a lawyer, you receive a lot of calls. Then they ask you say a lot of things and strategies how to fight this case and how do I do. Subsequently, you provide them services and then they don't engage you. Then your efforts are in vain. So retainer fee, that means to say before you actually talk to me, before you want me to teach, you retain me first. You pay me 500, 1,000 ringgit first. So then I draft a syllabus, I send to you. This is my planning, something like that. Okay, get me? So the fee actually is a prepayment, prepaid service for future legal service. Okay, so the retainer fee can vary. It depends how you arrange between the lawyer and client. Okay, actually, retainer fee itself is not specified inside the solicitor remuneration order SRO, okay, BC ruling, LPPR, all that, none of it. But in practice, the retainer fee could arise in several forms. Written retainer agreement. That means agreement say that, okay, once you want to engage me, front payment, the basic fee is like that. Regardless, you get, I mean, further trial or further matters, should it go litigation or a commercial contract, you engage me or not, you still have to pay. This is what it means. Oral retainer. That means verbal agreement between lawyer and client, and it could be implied also by the conduct of parties. So these are three retainer form. Okay. Like no, it's not consultation fee. It's like front payment before you use me. If you decide to, if you trust me, if I'm famous, right? Before I could advise on your case, before even the consultation happened, pay first. Okay? And question C, whether a solicitor has an implied authority to enter into a consent judgment without express consent of the client. All right? So as a general rule, once a consent judgment is entered in civil court, the parties will not have a remedy to appeal unless the consent judgment is compromised by fraud, misrepresentation, or lack of authority on the part of the lawyer. That means to say, if both parties agreed, sign consent judgment, lodged in the court, you cannot appeal. That means the matter end with the consent judgment. So consent judgment is very important. Okay. So whether a solicitor has implied authority to enter a consent judgment without the express consent of the client is a matter of authority of the solicitor. Okay. The statement given suggests, I mean the back statement, Wolf against HB Clifford, suggested the solicitor or counsel has implied authority to compromise a suit without express authority from the client, provided it doesn't involve collateral matter to the action. For example, out of scope matter. Okay, that means to say, if I retain you and the sole purpose of that particular retainment is for example, I have used here also, um, for divorce, for example. Okay, I ask you to represent me in a divorce petition in order for me to get divorced with my wife. But you have to remember the extent or the scope of authority is only for you to engage in the proceeding, divorce proceeding. I did not explicitly agree that the custody of my daughters should be given to my wife. I did not agree that half share of my law firms and my other companies should be given to the wife. Should any consent be entered between the lawyers in order for a settlement of this divorce proceeding, that means it's already a collateral matter. It's not pertaining to the main suit, divorce proceeding. Yes, you can do whatever you want, but not to decide out of your scope. Okay, so this is what it meant. All right, you can do a split. You can enter consent judgment, but you cannot act out of scope. So this is what it meant. And this is also the position in Malaysia. Perhaps you want to highlight this as well. You use the case of Yak Chi Meng and S. Paki Nadan against Ake Stollett. Okay, must remember that it's not that you cannot. The lawyer can enter consent judgment on behalf of the client, subjected to a few criteria. So long he protect the interest of the client that he acted for, so long he did not have any vitiating factors. That means you do not lie to your client, you do not represent to the client, you do not make any mistake of the facts and also law. The consent judgment is entirely fine, right? Okay. Whether I think this D, okay, whether the existence of and scope of duties in a client-solicitor relationship is to be determined only by reference to the express retainer. Okay, so my suggested answer to D would be express retainer is important in defining the formal agreement and primary obligations between the party. Yes, you have client and solicitor express retainer. That means a written or oral agreement. But nevertheless, it is not the sole determine of the whole scope of your relationship. So again, you have to do research on this case, Wolf against H.P. Clifford. It was demonstrated that solicitors could have implied or ostensible authority that can go beyond the express term of retainer agreement. The such authority is like what I have said to you. If it is within the business efficacy as the implied term within the reasonable contemplation. That means reasonable lawyer will act lah, filing notice, filing this, filing document. You cannot say that everything must be documented black and white in express term. Okay, so this is what it means. So, and apart from that also, even though the written agreement did not say that, oh, this is private and confidential, you must act diligently and in the best interest of the clients. But this is also being implied or bring into the so-called express retainer agreement by our professional codes of conduct and ethical rules. So this is what it means. Last but not least, express retainer signifies the contractual relationship between solicitors and client. However, it is tried law that solicitors also owe a duty of care. That means to say possible tortious duty towards his client. You can use the case of Ronda against Wosti. Same case, only you recycle. So what is your final position? In conclusion, the scope of duties of solicitor goes beyond to the reference of the express retainer. Okay? This question very hard. No need to do lah. This sort of question no need to do. Okay? So last question, 4A. With the aid of the relevant provisions and decided case, discuss 6 rules of etiquette that an advocate and solicitor must observe with respect to his performance of duty in the court. 12 marks. All right. So this question must do. Must do. Okay. So how you want to answer? Reference is made to Legal Profession Practice and Etiquette Rules 1978 in answering this question. Then you put an abbreviation LPPER. So you can submit that. You have to provide 6. So these are the 6 examples that I have provided. Rule 3, advocate and solicitor should not accept any brief if he is embarrassed. For example, in case of AG against Arthur Lee here, acting for family member. That means to say they have conflict of interest, whether it is pecuniary, that means in regard to money, or non-pecuniary. Okay, some other interest cannot. Rule 4, advocate and solicitor should not accept brief if it affects his professional conduct. For example, in R.S. Mutia against Pembenahan Fiber, uh, the Mrs. Maliga was actually disqualified by the court as she is acting for her husband company. Okay, cannot. Um, Apart to protect our client's interest, actually we do have a larger duty to the court. We are so-called the officer of the court. Okay, so you cannot do something that is you are tilted one side. By right, A and S should do justice, to the case. Okay, and rule 6. This rule does not allow a lawyer to accept case if he's unable to appear and represent client on the required date. For example, for instance, Sharikat Sautek Hua Reality, the defendant, actually the Malik and Joseph and Aula, the law firm, failed to show up at the appeal case, causing the plaintiff case to be struck off. So whenever you accept the brief, regardless if it's a case management trial hearing date, you must attend. Otherwise, there is a tendency or possibility that the case will be struck off in totality by the court. And then the client will automatically lose his case. So this is ready for a case. Whenever he's accepting the case, he must be always ready. So this is under your rule 6 of LPPER. Okay. Rule 12, A&S shall not cause delay to the proceeding. Okay. Now we have a strict pre-trial case management, and also the court is quite strict with the adjournment issue. You cannot simply adjourn a hearing date without solid reason. So you can use a case of PP against Mokhtar Dolatif here. Okay, so cannot simply adjourn the case. Rule 15, advocate and solicitor must show respect to the court. So you are a court officer. By right, this court is an honorable court. Judiciary image and reputation all there. Justice system is all in the court. You cannot simply shout at the magistrate, okay, intimidating the witness, okay, making some fool out of the parties there. You cannot do like that. Okay, so the case of Karam Singh here against PP, the advocate and solicitor actually argue and also allege the magistrate being biased. So Mr. Karam was eventually cited for contempt in the face of court. So again, advocate and solicitor is the officer of the court. It's important to respect the court. So last rule, because they ask you to give 6, you must give 6. You cannot go beyond that. So how to explain to you? We are advocate and solicitor, and you are to be, right? So you must obey what is the requirement of the answers. If you are giving the impression to the examiners, you yourself is a very tricky person, I think it will cause more harm to you, all right? In getting marks from them. So rule 17, advocate and solicitor should not cheat or deceive the court. So it's very important for an advocate and solicitor to be honest and truthful. So if you conceal documents, for example, in the case of Chia Cheng Hock against PP here, you might be charged, or you will be lodged complaints in advocate and solicitor board by the judge or the opposing party. Okay, very important. So these are the 6 rules that I have used. Of course, you are at the liberty to use whatever rules that is under your LPPR. I think this is a pretty simple question. Okay. And last question, Baka here, an advocate and solicitor has a passion for architecture and subsequently obtained a degree. Okay, sorry, where is it? Okay, subsequently obtained a degree in that discipline. He intends to practice both as an advocate and solicitor and part-time basis as an architect. As his practice is predominantly in the area of motor insurance, he has enlisted the assistance of Mutu, an experienced legal clerk, to handle his office and his brief, including to canvass for brief at the hospital with an arrangement that all profits from the legal practice shall be shared equally between them. He has also allowed Mutu the liberty to sign all checks for the clients as well as the office account. Discuss the relevant issue in relation to LPA and rules met thereunder. 8 marks. So again, my style, okay. First issue is dual profession, whether architect, part-time, part-time architect and advocate advocate and solicitor are allowed or not by Bar Malaysia or our LPA. Okay, so I will put it one heading to show that to the examiners that I address this first issue. So I will submit in such a way. Baka is an advocate and solicitor with valid CGL annual and practicing certificate. So this is one profession already. You agree with me? Right. Regardless of his part-time basis, should he wish to practice as an architect, he will be required to register for a practicing certificate under Malaysia Institute of Architect. So architect cannot be part-time, must be a qualified architect. Just like a doctor. For example, if I want to practice part-time doctor, I have to register for APC, we call APC, Annual Practicing Certificate under Malaysia Medical Council. So it's already conflicting. Cannot. So I have to give up my medical license in order for me to join this legal field. So this is the law here. Okay. So which section are we relying on? We rely on section 30, subrule 1, subrule C of LPA, which provides that legal professions to be advocates, only profession. So here, Baka, advocate, solicitor, one profession already. Architect, another one profession. Clearly cannot lah. So Baka shall not fall under any part-time exemption under BC ruling 2019, chapter 1201. Cite the case of Sheikh Mubarak, Sheikh Ahmad against Majlis Peguam Malaysia. So this case also very famous. Accountant and solicitor at the same time, whether it's allowed or not. So clearly it is not allowed. So this is the very clear now. So no dispute. Dual profession is not allowed in Malaysia. So second thing is touting. Straight away write your opinion because you know, and this is a 8-mark question. Don't spend too much time. So you submit that Baka is liable to section 94, subrule 3, subrule H of LPA, which provides that it is a professional misconduct in accepting any employment in legal business through tout. Okay? So what happens here? Touting occur when Baka asks Mutu, an unqualified person, to hunt for cases for him. That means to say ambulance chasing. This is a term, ambulance chasing. Because he's doing motor vehicle accident case. So he need to wait in the ambulance or in the hospital ward to see if he could get the victims of the accident in order for him to bring this case to personal injury claim in the court. So cannot lah. All right. So breaches of LPPR. Okay, you categorize your submission into heading, I think will be much more advantageous for you. So Baka here had obviously breached Rule 51 for touting as aforesaid discussed. All right. And he's also violating Rule 52 of LPPR because he shared profits with Mutu and unqualified person. Okay. Furthermore, there's also a potential breach of 53, Rule 53, by engaging Mutu as an agent for the purpose of sharing commissions and profit. Okay. So make your sentence sound and sweet. So breach of solicitor and account rules. Last paragraph, Mutu is authorized to sign the checks and also manage the law firm's account. So can or not? Cannot. So you have to set that as the sole proprietor of the firm, Baka must and also duty and legally bound by solicitor account rule to maintain the client account and office account under, so this one, under Rule 7A, Sub-Rule A of Solicitor Account Rule 1990. In practice, this one is seriously very important. When I was a student, I also didn't read much, but after I become a partner, well, I read this in detail because most of the lawyer got their suspension or struck off because they do not follow this solicitor account rule. Okay, so that's why now in practice, I become very careful. So Baka by right should be only person because it's sole proprietor that could sign the check or whatever withdrawal of administration of the client's account. Okay, so you further said that failure to maintain account is fatal to Baka's career. Because as in the first question, we have seen that for you to make annual declaration, you need to submit accountant report. If your account is flow, the money in out just like that without solid reason, the accountant will not issue this accountant report to you. So there's a risk that Baka cannot renew his seizure annual should he not be able to tender an accountant report. Worst come to worst, so this is worse. Baka would be at risk of getting sued for professional negligence and subjected to disciplinary action by SDB, i.e. struck off the rule should there be any misappropriation of client's account money. Because you leave it to Mutu. You don't care. Okay? So this is how you should drafted the answer. All right. I think that's all for the cases, what we call today. And shortly speaking, professional practice paper, you have to practice. Okay, you have to practice. Practice will make your answer much and much better. All right. So pretty easy, except for question 3. And subsequently, I will need to load the what we call the video and also send the slides to the group. Do not worry. Should you have any question or doubts, please always come back to me. All right. If there is no other further question, as usual, then probably